wanted to say good afternoon and thank you all for joining us today. I'm Dr. Wilcox, the Community Coordinator at the New Jersey Healthcare Quality Institute. The Quality Institute is a nonprofit, multi-stakeholder advocate for the safety, quality, and affordability of healthcare for everyone. The Quality Institute oversees a statewide community health initiative called Conversation of Your Life, also known as COIL, which is a program of our Mayor's Wellness Campaign and generously supported in part by the Horizon Foundation for New Jersey. COIL aims to engage communities and residents in crucial advanced care planning conversations. We discuss topics like hospice and palliative care, various advanced directive documents, and how to communicate your wishes to your loved ones and healthcare providers. Our programming is being adapted to various cultures and languages. A public health crisis such as the one we're now facing with COVID-19 tests our strengths and highlights our weaknesses. The pandemic is prompting many people to consider the advanced care directives they may have been putting off, and we want to make sure that you have all the information and resources you need to help you make the decisions about the type of care that you want. We're going to continue to provide resources and have these crucial conversations remotely through digital resources, podcasts, and webinars like this one today. Before we begin, I want to go over a few housekeeping items. Please know that this webinar is being recorded and a copy will be posted to our website, www.njhcqi.org, later today. All phone lines will be muted for the duration of the program to limit background noise. You may ask questions at the end of the presentation by typing into the chat box or clicking on the raise hand button. The topic for today's presentation is honoring your wishes, being medically and legally prepared. Please be advised it is not the intent of this program or its speakers to provide clinical or legal advice. We're honored to have Dr. Bibin George, Claudia Gallagher, and Gerald E. Rothkopf joining us for today's discussion. After a brief introduction from our panelists, we'll go ahead and have a moderated discussion and then afterwards open it up to the audience for Q&A. So Dr. George, if you'd like to introduce yourself, the floor is yours.
Good afternoon, everyone. I just want to thank New Jersey Healthcare Quality Initiative and COIL for just giving me a few minutes to speak to you guys today. Little background about me: I'm a board certified family physician, and I work as a primary care physician in the hospital setting. So that's called a hospitalist. So currently I'm a hospitalist at Inspira Medical Center, Mullica Hill. I also have a passion for palliative care, which we'll talk about in a little bit, but I serve as a palliative care medical director for Baeta at Inspira, and I've been working in the South Jersey area for about 10 years now.
All right. And Gerald, if you'd like to introduce yourself next.
Well, I also would like to thank you for hosting today, inviting me to join this illustrious panel. My name is Gerald Rothkopf. I am managing attorney at Rothkopf Law Group, an elder care law firm, both based in New Jersey and Pennsylvania. Our goal is to determine how an individual can get the best quality care possible and then figure out how to pay for that care. We provide a holistic experience for the individual by incorporating healthcare advocacy, care coordination, geriatric social work, as well as attorneys to assist individuals to navigate the long-term care process. So welcome and thank you once again.
Of course. And Claudia?
Hello, I'm Claudia Gallagher. I am an associate attorney at Scott Counsel PC. It's an elder law firm, and it's a similar setup to Rothkopf Law. We have the social worker on staff, so we can give that holistic, experience and service to our clients.
All right. Thank you. And without any further ado, I'd like to begin the panel discussion. So if any of you participating have a question for any of our panelists, please type it into the chat box throughout the duration of the presentation, and we'll get to as many of them as we can before the end of the webinar. So Dr. George, I'd like to start with you first. For those in attendance that aren't too familiar with advanced care planning, I wanted to ask, what is advanced care planning and why is it so important right now, especially during COVID-19?
So I think it's a great question, and it's a really important question. So just as a simple answer, advanced care planning, it's a conversation. So a conversation in real life is, really leading up to this. So it's a conversation that a person has, with their loved ones and also their healthcare providers. And it's a time where you're able to discuss really what your preferences are at the end of life, and then putting those preferences or those ideas and thoughts that you have in writing, just in case that you are unable to speak for yourself. And the main reason that we try to do advanced care planning is that, it really empowers the patient. And our goals are always to make sure that we are following what our patients want, or we want to respect those wishes. And to have this conversation prior it really helps us to empower the patient to complete this. So it involves a few different things, and it really involves learning about really what the types of decisions that you may need to make, and then thinking about those decisions ahead of time so we can prepare, and then letting others know, especially your loved ones, and like I said, your healthcare providers. So during this conversation, there's a few important parts that kind of go with it. So the patient themselves, we're all different. I mean, these conversations go differently for every person that talks about it. And the reason why is that we have different values, we have different beliefs, we have different goals for our healthcare. And these different values and beliefs that we have, it changes the way that we want our healthcare to proceed. And so that's why it's important that the healthcare professional is able to talk to the patient, let them know, what is your diagnosis, what is your prognosis, what treatment is there, what alternatives of treatment is there, and then what will be the benefits and burdens of any type of life-sustaining treatment. So when we talk about life-sustaining treatment, we're talking about things such as CPR, and then using a ventilator. So for a lot of us, we get a lot of our medical education, or we see different things on television, because we see these things happen on many different shows, and it gives us a glimpse of what it might be. But just to talk about it just for a second, CPR is also cardiopulmonary resuscitation. And the point of that is really to restore your heartbeat if your heart stops working, or if you have an abnormal heart rhythm. It could involve certain different things, including chest compressions, is when we repeatedly push in your chest to kind of restart the heart while putting air into your lungs. But if those things don't work, or if we need to, we also do things such as electric shocking, which is also known as defibrillation, and then medicines to kind of restart the heart. So it's interesting because we see these things on television a lot of times, where we see people undergo CPR, and by the end of that show, their heart rhythm is back, or everything is back to normal, and they're awake and talking to you. On contrast, what we do know is that CPR in a young, healthy person might resume that heartbeat normally right after CPR, but we also see that it doesn't succeed as often when you're much older, you have multiple chronic illnesses as well. There's also risks to CPR, which include breaking of ribs or different things along those lines. And then a ventilator, it's an emergency treatment that we use to help you breathe. So that includes using a tube, which is connected to a ventilator machine, which goes in your mouth, in your throat, in your trachea, or also known as your windpipe. And that way it helps the machine breathe for you. So same thing, as we get older, sometimes it's very difficult once we get on these machines to be able to come up as well. And it can be very uncomfortable. So we try to keep patients sedated when they're on that machine. So that part of the conversation is when we talk about life-sustaining treatment. So the most important thing is the healthcare.
Can I ask you a question related to COVID-19 and the use of ventilators, please?
Sure.
Great. So when COVID-19, the pandemic began in early March, obviously there was this push, we're not going to have enough ventilators. Mainly in the New York City area for obvious reasons, and not as much in New Jersey, but it was an issue nationwide. And we were getting questions from clients, elder law attorneys, for example, about, well, does my advanced directive address the use of a ventilator? What do I do if my mom, who in a nursing home, goes to a hospital? Do I have authority to tell the healthcare providers as our healthcare proxy not to use a ventilator? Can you talk about advanced directives in relation to your experience as a hospitalist, as to the effectiveness, the efficacy of advanced directives related to COVID-19 and the use of ventilators?
Oh yeah, and it's a great question. I'd be more than happy to. So I mean um, the one thing when we think about advanced directives, it's for planning for the future. So obviously at that point when you probably did the advanced directive, COVID-19, these different pandemics or wasn't an issue at that time. But the difficulty that sometimes we have with an advanced directive versus like a specific medical order is that it makes it a little bit harder for us at times when we're talking to the family about what to do in a specific situation. So one thing I was going to mention is that when you do these advanced directives, or if you're doing medical orders as a pulse form, it's important to talk to your family members because there's certain situations that may fall outside of that advanced directive. Because oftentimes it talks about serious terminal illnesses in the advanced directive, but sometimes we're not at that point yet. And the most difficult part of that is really, what happens kind of in the middle of the night. So, I mean, when we have these conversations with our families, we see these patients get sick very quickly. So we see patients that come to the hospital with COVID-19, they look very stable, but they can really decline or deteriorate within several hours. And that might be just one of those middle of the night phone calls. So that's a lot of times we talk about things such as medical orders or what we call the pulse form, which is a practitioner order for life-sustaining treatment. So this can go it can go in conjunction with advanced directives. So a lot of times we are encouraging families to also have this completed because that is a specific medical order that we are able to follow as well. But I mean, to get back to your point, it is a difficult conversation because, it is hard sometimes to kind of follow through with the advanced directive when we're in these situations where it's time is of the essence type picture, and it's hard to kind of go through some of these legal documents at that time.
Thank you.
So this brings me back to a really good point. Is the question? The other question was, why is this so important? During this COVID-19 pandemic, and I think we just talked about that, pretty quickly. But another issue that we have with COVID-19 pandemic as well is that things that we don't see is that family caregivers, we don't think of it as this, but they're really supporting our patients at home. I mean, they're giving countless hours of unpaid help to their family and their loved ones. And it might not be just a family member, it might be a neighbor who is actually a caregiver, but their resources are so limited because we have strict social isolation, we have a lot of telehealth visits. So that part of isolation gives an even bigger burden to our caregivers at home. So, I mean, that's another reason why it's really important to have these conversations prior to them coming to the hospital, even though it's not an easy conversation. So it gives some clarity to the patient as well as their caregiver on what they would want to do in a case of an emergency situation. I can tell you New Jersey in itself has one of the highest numbers of days in the hospital, highest number of days in the ICU, and the highest number of tests and procedures at the end of life. It's more likely that a New Jersey resident will die in the hospital than in a home setting during these critical illnesses after being in the ICU. And one of the reasons why is because we need to have these conversations prior, preparing them.
Of course, and that kind of leads into my next question is there ever a bad time to start the conversation? Because end of life care always has like this like taboo like aspect about it where we don't talk about end of life. We
Right.
try to avoid that topic. So is there ever a time that's better than others to bring it up, or is it just something that you think should be addressed at any time, or like after you turn 18 or when you're in the hospital in the ICU? Like when's the best time, or is there ever any bad time to have the conversation?
Yeah, I mean, it's another really good question. After the age of 18, definitely you can, make a legal document or a medical order. And it's really challenging sometimes when you think of death and dying because it's just not a conversation that we typically have. I mean, but the reality of the fact is that at any age, you can have a medical crisis that could leave you too ill to make your own healthcare decisions. So, God forbid, something could happen where you're in a terrible accident or something happens where you're not able to make those decisions known. And it's important to be able to talk to your healthcare provider as well as your loved ones about in those situations where you can't speak for yourself. What are your thoughts about what you would want to do at that situation? And the other part to really think about is that this is not a one-time conversation. This is a conversation that kind of transcends our life and every different aspect of our life. When we're 18, our mindset's very different than when we're 25. and then when we're 35. We might have a few kids by then, or we might have different things or responsibilities that might make us think differently about, this is now my outlook on life through my, my shared experiences in the past 30, 40, 50, 60 years. And we can always address that in an advanced directive as well as a medical order to update it as well. So it's a good thing to know that it's not a one and done deal. It's something that needs to be revisited. Also, as an example, sometimes you already have a legal document or a medical order which says one thing, but then you end up in the hospital, you were on a ventilator or a breathing machine for a couple days or a week, and then you realize at some point that this is an experience that I never want to go through again. So that may be a time to revisit that as well. I mean, other examples is just planning for if you have hypertension or high blood pressure. One question would be, if your hypertension or your blood pressure and your diabetes led you to a stroke, at that moment, it's important to have these moments of clarity prior to these things happening. Other examples would be if a patient is asking, about advanced directive, that's a definitely appropriate time to talk about advanced care planning. If they're having complications from a serious illness, if they are planning for any type of surgery or planned procedure, to talk about it before. But there's also different stages on what conversations to have. I mean, if you're young and healthy, one conversation might just be, who would you want to be like a healthcare proxy or someone to help you make decisions? Or if you had something like a terrible car accident and you had some type of permanent injury at that point. But as maybe your medical conditions evolve, then you might want to have different conversations about, based on this serious illness, what would you want to do with this type of treatment? So it's an evolving conversation, but I think it's really never too early to even start the conversation.
I would just like to take a moment to expand on a couple items that Dr. George touched upon. One of those, he talked about having the conversation, and that's the topic of today's webinar, and that's so important. The problem with advanced directives is it can be subject to interpretation, as Dr. George stated. It's just words. It's black and white on a piece of paper. Someone has to, whether it's a family member or, like Dr. George, a healthcare provider, has to interpret that and apply that if you're dealing with an incapacitated patient who's not able to make his or her own decisions as to their medical needs. So the most important part of the advanced directive is not, I would argue, the document itself. It's the conversation that occurs around the document. A lot of people mistaken signing an advanced directive for having that conversation. You gotta have that conversation with the family member. Not easy to have, but that's a kitchen table type of conversation that needs to be had before a crisis occurs. It's not a pleasant conversation to have, but it's important to know what your parent, your spouse, your sibling, with their wishes are, because otherwise it's subject to interpretation. And I would also like to add, when we talk about end-of-life planning, over the past year, we all have an additional tool in our end-of-life toolbox that I'm sure Dr. George and as well as Claudia is aware of, and that's the New Jersey Aid in Dying legislation or law that went into effect almost a year ago on August 1, 2019. I don't know if Dr. George has experience with the New Jersey Aid in Dying legislation, but it's something, if it's an end-of-life situation and you have a competent, emphasis on competent patient, it may be a discussion worth having. There's a lot of limitations on it. It can be controversial in nature. There's an opportunity for the healthcare professional to opt out. That's way beyond the scope of our discussion, but I just would like to advise those who are participating in this webinar that it's available for the individual competent patient to utilize in the appropriate end-of-life circumstances. And New Jersey, I believe, is one of 8 states.
I was going to just say that, I completely agree, because it's so important that that conversation is really the basis for everything, because I can't tell you how many patients have come in where, like Gerald mentioned, their family members incapacitated, they can't make those medical decisions, and then you ask about advanced care planning, and they tell them, well, I'm pretty sure mom has this document or this living will or something at home, I can go grab it for you. And then you try to ask them, when you guys had that conversation, how did it go? What did you guys talk about? And there's just many, many times where that conversation was never had. So that even though someone may be listed as a healthcare agent or a healthcare proxy, but they never had that specific conversation, with their loved one. And so it's absolutely true. The paper is just, like you said, black and white, it's a document, but the conversation is the most important part of it.
Okay, and thank you. And before we move on to the legal aspect, I have one last question for you, Dr. George. For the people who are unaware, sometimes they get confused between hospice and palliative care. So if you could just break down what each one is and what is the difference between them, it would be greatly appreciated.
Sure. So it's good to know, just as a basis, that palliation or palliate, it comes from the Latin word cloak, so giving you just like something to cloak your symptoms for. So when we talk about palliative care, and I'll try to really emphasize the specific difference between palliative care and hospice at the end, but so palliative care, it's a specialized type of medical care, and it's for anyone that has any type of serious illness. When we think of serious illnesses, a lot of times we think of just cancer, but it's not just specific to cancers. Congestive heart failure, rheumatoid arthritis, advanced COPD. There's many conditions that a patient has that can be considered a serious illness. And I just want to say that palliative care as a whole is very focused to the individual patient itself and their family members. So it's a very family-centered approach to medical care. And the main goal really is to address and provide relief from the symptoms of that specific illness that they have. We want to improve quality of life for the patient and their family. And the way that we approach this is that we have a special team that's trained in palliative care, which includes doctors, nurses, physical occupational therapists, social workers, and we all work together with the patient. There are other doctors as well to really give them that extra layer of support. And it's really based on the patient's needs and not their prognosis. So like I said, nothing in medicine is cookie cutter. Everything is patient specific. One patient's needs with the same diagnosis varies very greatly from someone else's needs as well. And another really important part is that palliative care, you can receive this palliative care in addition to any type of curative treatment you want to have with your illness. So say you have cancer and you're undergoing chemotherapy, palliative care is in addition to that. It doesn't stop the chemotherapy, it doesn't stop your radiation therapy, it's just really giving you that extra layer of support. And it is appropriate at really any stage of a serious illness. So it's not that palliative care is appropriate only towards the end of that illness, but we want to be there towards the beginning as well. So when you do go for chemotherapy or when you do have COPD exacerbations, we're there to help with your symptoms to provide you that relief. And then we focus on many different symptoms, not just pain, fatigue, depression, nausea, constipation. A lot of these symptoms are really overlooked in the treatment models. And also there's social situations, there's psychological situations, financial, where there's a lot of difficulty, and we try to help those patients as well as their family members as well. And it's really in many different healthcare settings, in the home, in the hospital setting in itself. So like I said, so just to emphasize, palliative care is when you need an extra layer of support and you're going to continue treatment for your illness. Hospice, so we say, one thing where we say is all hospice care is palliative care, but not all palliative care is hospice. So hospice, we really focus on towards the end of life when you have a prognosis of less than 6 months. So that's a point in your disease setting, when your life expectancy is less than 6 months and you're really not planning to undergo any type of more curative treatment for the terminal illness that you have. And then we focus on many different things in hospice care, including symptom management, but the same psychosocial, social issues are also played in hospice care. It's just that with hospice care, you're not undergoing curative treatment for your illness, whereas palliative care, you're continuing any treatment that you want for the illness that you currently have. And those are the main differences really between palliative care and hospice.
Thank you for that. And if anyone has any questions for Dr. George, please feel free to type them into the chat or the Q&A box, and we'll get to them after our legal presentation. So switching gears, I have a question for you, Gerald. What is life care planning for those of us that don't know what that means? Oh, you're on mute. Let me unmute you.
Sorry.
No?
So life care planning can mean different things based upon what you're applying it to. Life care planning can mean, say you have a child who's been profoundly disabled since birth, charting out his or her future and looking at the potential medical costs. That's one form of life care planning. That's not what we do. What we do is, traditional elder law has really been focused on an asset preservation advocacy, meaning looking at public benefits via Medicaid and VA and attempting to protect assets or help divert, look at different alternative payment sources like Medicaid, for example, to pay for long-term care, for home care, assisted living, and specifically nursing home care, and then attempt to preserve a portion of funds for a spouse, a disabled child, the children, next of kin, etc. That's traditional elder law. And for the first, I've been practicing elder law for over 20 years in South Jersey. And for the first 5 years, that's what I did, how to qualify an individual for Medicaid and preserve funds for children or a spouse. It has a purpose, but I needed a higher calling. And I decided to transition to what I believe clients were looking for, what family members of loved ones, caregivers were looking for. And that's to help navigate the long-term care process. And that's the most important thing we do. Healthcare advocacy. I tell people I'm an attorney 30% of the time, the other 70% of the time, I'm a geriatric social worker. And really that is what families in my mind, and I've learned over 20 years, are looking for. To help navigate these long-term care issues, some end of life, as Dr. George referred to, but you have someone with early stage Alzheimer's disease. And what resources, you don't need nursing home care, it's clearly not end of life. You may have 10 plus years of good living left. But during that 10 years, how do we maximize this individual's life to the fullest, while at the same time easing the burden on a caregiver's spouse of 50 plus years or caregiver children who are raising their own families and working? Our goal is to help families navigate the long-term care process using a holistic fashion that will employ traditional elder law, meaning wills, powers of attorney, advanced directives, as was already mentioned, setting up a trust, looking to qualify for long-term care benefits via VA, via looking at their health insurance, via the state Medicaid system. But I wanted to go beyond that. My goal, if I'm a true advocate for the caregiver or our client, the senior, the most important thing is care. How do we get the best care? And then we'll figure out how to pay for it. So life care planning really is looking at a different way to address an individual's needs that are person-centered and have a consumer advocate as an elder law firm behind them, and having other types of non-legal professionals, long-term care professionals, at their disposal. So rather than being asset-centered, life care planning is person-centered. We look to where the person is and their level of care needs, and we structure a long-term care plan around the legal needs and the healthcare needs of the individual. So that, in essence, is life care planning. I was one of about 20 law firms across the country that back about 12 or 13 years ago founded an organization called Life Care Planning Law Firm Association. I was privileged about 5 years ago to be a president of that organization, and so it's a way to provide a holistic services while ensuring that the primary focus is care as opposed to asset centered. So there's a longer answer, but in short, that's really the way we do it. And a lot of people, when they come to us, the first thing they think, they're coming to us because they think that we hide the money. We elder law attorneys hide the money. And my goal is to change the paradigm. I get what you're talking about. You have a special needs child, you have a spouse of 50 plus years. Very important to protect the assets, provide additional income and assets. But hold on there. Let's focus on the care. Let's get the care, and then I promise you, we will figure out how to pay for that without going broke. That's life care plan.
Thank you for that. And I did hear you mention powers of attorney, wills, and everything. So I want to take a step back. So for those of us who aren't aware of what a power of attorney is, Claudia, would you be able to maybe give us a little background on what is a power of attorney and what are the different types?
Okay, yeah. So power of attorney, it's a document that you use to authorize someone to act on your behalf. And the two types that you're going to be using are a financial power of attorney. So you're authorizing someone to help with your financial affairs. So that can be, writing checks, paying bills, selling property, opening and closing bank accounts. And then the other main one that you're going to be using is a medical power of attorney, and that's the Advanced Health Care Directive that was mentioned before in the other presentations. And that's your power of attorney will be then making medical decisions for you, decisions about your care.
Got that. And does a power of attorney ever expire, or is it once you have one, is it for life, or does it ever expire?
It doesn't technically expire. I mean, there's nothing in law saying that they only last a certain amount of time. Most documents themselves will say that it just ends upon death or if you revoke it. That being said, it's only as good as how long it's going to be accepted. And I found a lot after 8 to 10 years, a lot of financial institutions and hospitals stop accepting them. So once they get past that 5 to 8 year mark, you probably want to consider updating them, checking to see if banks are still going to accept it.
Got that. And what's the difference between an executor and a power of attorney?
So an executor is really only going to be used after you pass away. So an executor is someone you name in a will, and they're going to be handling your estate. They're going to be figuring out, what's in it, what bills you owe, and then eventually making the distributions. Whereas in a power of attorney, they act while you're alive, and you may not be able to act for a particular reason, but once you die, their powers are no longer apply.
Got that. Okay, and what's the difference between a living will and a living trust?
So a living will, it's going to be a medical document, and it's similar to the Advanced Health Care Directive, whereas medical power of attorney, that names an agent that is going to make those medical decisions. If you can't, the living will specifies what those medical decisions are, and I think we've touched on them a little bit. That's like, do you want a feeding tube? Do you want a ventilator? And what condition you have to be for those? Whereas a living trust, that's going to be a document relating to finances and how you structure your assets. So that's going to be how you structuring them, who you want them distributed to after your death, that sort of thing.
Got that. And how many different kinds of trusts are there?
I mean, there are multiple kinds. The two important ones for elder care planning are the revocable trust and the irrevocable trust. Irrevocable trust, that falls under the living trust, and it's that's one where you can change at any time. You can be trustee. You can all of the distributions can be made to yourself. An irrevocable trust is you put your assets in the trust and then you give up control. You're not going to be the trustee. You can't change that trust document. You can't revoke it at any point in time. And that's more in the asset protection part of elder care law. That's going to be, if you're thinking about Medicaid, that might come up down the line. You use the irrevocable trust so that what you put in the trust is not counted towards your asset.
Thank you. And circling back to the medical documents, I've heard that completing a living will or an advanced directive requires a lawyer and costs money. Is that necessarily true?
Not necessarily. There are forms online that you can fill out and have notarized, and also sometimes hospitals will have you fill out something that would, effectively be a living will. That being said, if you're going to an attorney, that's just a little bit more security. The attorney, they have experience, they know which provisions to put in, they're up to date with the laws. They might anticipate circumstances that will arise that you would not necessarily think of. So if you use an attorney for these, you're going to have better protection and better security with them.
Got that. Thank you for all of that. And I want to circle back to you, Gerald. I wanted to.
Before we get that, I just want to follow up on a couple of Claudia's comments, please.
Okay, of course.
First of all, as to the powers of attorney, most people think, oh, if I do a lot of consumer presentations, and I always ask, what's the most important legal document you need? And without fail, the vast majority are going to say a last will and testament. Important document, but doesn't help you live, does it? Why doesn't it help you live? Because it's only effective when you're dead, right? And then executor will take over, as Claudia briefly discussed. The most important document all four of us, as well as all 25 participants of this Zoom meeting, can have are durable financial and healthcare powers of attorney. Why? Because it helps you live. It helps either a surrogate, a third-party surrogate, make important end-of-life decisions, as Dr. George emphasized. It helps for someone who has significant cognitive impairment due to other Alzheimer's or other forms of dementia. It helps a child or a spouse access their assets to pay needed expenses. Without a financial power of attorney, and if an individual does not have the cognition to understand what they are signing, a guardianship is needed. You want to avoid a guardianship if at all possible. The most basic way to avoid a guardianship, which is court-supervised decision-making in the county in which you reside, is to have durable financial and powers of attorney in place. What does durable mean? Durable means it continues to be in effect after disability occurs. There's also another document called a springing power of attorney, which generally is not recommended. But durable means that it continues to be in effect. So if you get nothing out of this presentation today, besides your advanced directive, execute durable financial and healthcare powers of attorney to help you live. You don't lose the ability to make your own decisions. It's a security blanket that will allow a third party, it could be a child, could be a spouse, could be a good friend, could be an aunt, could be an uncle, could be a cousin, to make decisions if you, due to dementia or other forms of cognitive impairment, are unable to make your own decisions.
Thank you. And we do have a question from the audience. They wanted to know if these legal documents are state specific, or do they apply? Say you fill it out in New Jersey with an attorney and you're in California and something happens, or you move to California. Does this document still apply across state borders, or will only?
First of all, each state has their own signing provisions. Each state has their own specific requirements. For example, we practice in both Pennsylvania and New Jersey. There are separate Pennsylvania forms for financial powers of attorney and certain clauses that must be in a Pennsylvania document as opposed to New Jersey. So if someone is moving, which is very common, from a nurse from their home in Pennsylvania to an assisted living in New Jersey where the kids are, we will re-sign their documents. But generally speaking, if you execute a document in one state, I do recommend having an attorney review the document in the new state you move to make sure it's still effective and meets your needs. If you execute a will in one state as opposed, and then it's very common to execute a will in Florida, for example, when you retire, and then when a child needs it, and the children are still living in the New Jersey or the Philadelphia region, and then the parents moving back to the roost, if you understand what I mean. And very common. And then the document's still valid. You want to see if it's certainly want to see if it needs to be updated, because tax laws could certainly change from state to state. Signing requirements from state to state. Some documents need to be notarized in one state. They don't need to be notarized in the other. Some have different witness signing requirements. So all of this is important to keep in mind, especially if you're toggling between states, so to speak.
Thank you. And I do want to touch on how COVID-19 has impacted your operation. So have you seen an increase in the need for life care planning? I want to tie back to what you were talking about before.
Well, there's an increased need for planning. I mean, the problem is, I would argue that the average consumer doesn't even realize it. Why? Because the average consumer is fear, meaning that uncertainty brings about lack of planning, I would argue. Same thing I would say from Dr. George's perspective, in the medical, I'm using legal versus medical analogy. Dr. George, you're a hospitalist, you don't work in the ER, but I'm assuming you don't, but you know, one of the beautiful things about COVID, and by the way, I'm being slightly facetious, it has cured heart disease. It has cured stroke. Why? Because people are not showing up since March in Cooper's ER, are they? At the same, you know, they're not showing up with symptoms of stroke. They're not showing up with a heart attack and the like. Why? Because they're afraid to go to the ER. So to analogize from the life care planning or elder care sphere, from a legal and financial perspective, people don't like to plan in times of uncertainty. So what I mean by that is that there is a huge need out there, because what we're dealing now, and one of the impacts upon not just our operations but of seniors, is social isolation is devastating. And I would argue that if COVID does not kill our 85-year-old client, social isolation will. Depression will. So one of the real downsides of COVID-19 is, especially for those at home or who don't live with other seniors who don't live with others, or certainly in independent assisted or nursing home, is social isolation. So one of the beautiful things I would argue about our practice is, yeah, we had to pivot many, many different ways, because we can't visit our clients. Family members can't visit their own loved ones in long-term care communities, except up until recently in New Jersey, Father's Day, they began outside visits. But even those, I would argue, are significantly restricted. And if you've ever been to a busy deli, it's like, got to take a number. That's the way it basically is. And it's been very difficult. But thank God we have those 5 geriatric social workers who are able to advocate and communicate with long-term care providers and really help to facilitate that communication. And that's been huge to minimize that social isolation. But there is an increased need out there. But some people, I would argue, inappropriately think, well, my mom's at home, why do I need an elder law attorney? Because we're not paying $12,000 a month to the nursing home right now, because I don't want her exposed to COVID. Why do I need an elder law attorney? Well, you want an elder law attorney to avoid a crisis in the future, I would argue. And so, I mean, so there is an increased need. However, the perception may be slightly different.
Got that. And you kind of touched on it already, but I was going to say, what types of challenges and barriers have been created due to the pandemic? But you kind of touched on it. I don't know if you want to elaborate a little further.
I always can. The challenge, as I said, is minimizing that social isolation is one big, and and the restrictions, and I understand why the restrictions are there, especially in early March. COVID has decimated assisted livings and specifically nursing homes in New Jersey and throughout the country, as I'm sure many have read about. or possibly witnessed firsthand, unfortunately. And there was a lot of barriers. I mean, you know, our staff, the vast majority of our staff is still working remotely. And, you know, in elder law, it's family, as I mentioned before, family table conversation. And, you know, and include the whole family in that conversation. It's a very intimate type of legal practice, in other words, where a lot of hugging going on because it's a job well done, you know. So we had to change what we do for a living to a certain extent, and how we operate. You know, we especially with our seniors, because with pre-existing conditions, as you all know, very susceptible to COVID. So you know, you got to watch those individuals, specifically pre-existing conditions. And a lot of our clients have pre-existing conditions: diabetes, dementia, MS, Parkinson's, and the like. So how do we continue to provide quality services from afar? And thankfully, the law helped out. There are remote notaries now, both in New Jersey and Pennsylvania. So we're doing FaceTime signings of legal documents in hospitals, assisted living, nursing homes, in an individual's own home. So that's some of technology certainly has helped with the workaround as well. But what I would say is that one of the things, I'll say a couple good things, because I try to be a positive person. One of the good things I think that of COVID, if you want to call it a good thing, it has really exposed the overall inefficiencies of our healthcare system. It has, and that's a good thing, because it brought to bear all that is wrong with our healthcare system and long-term care. And so what I will say, and again, people far smarter than I am will need to fix it. My goal is not to work in the system. My goal is to advocate to change the system, because the system, how we pay for our seniors and take care of our most vulnerable population, is broken. And COVID exposed that for all to see. So what I would say is that if we as a society do not rise to the occasion at this point and address the inefficiencies and the failings of our system to take care of our most vulnerable residents, this pandemic will be for naught. We need to do better as a society to take care of our most vulnerable residents. And it can't be business as usual hereafter. We have to change the way care is paid for. We have to increase the reimbursement for home care. We have to address the inequalities between white America and Black and Latino America that COVID exposed. So that's the benefit, I would argue, if you want to call it that, is that there is so much room for improvement. And my hope is that we as society and our government and our state entities will now take it upon themselves to see the issues and address them for the better.
Of course. And thank you for that. And just in light of time, I do want to get to some of these audience questions that are posed. So I want to say thank you to our three presenters for all of that helpful information. And I just want to remind everyone that this webinar will be available on the COIL webpage, www.njhcqi.org/COIL, so that you can review the information you may have missed, and you can share it with your family members and friends. We also have other resources available for you, such as our advanced care planning, preparing for the unexpected one-pager, where we've compiled trusted resources, all accessible from home, to help you and your loved ones start thinking about your wishes and strategies for how you can comfortably approach these important conversations with one another and your healthcare providers. We encourage you to take a look at this document and share it with your family and friends. And stay tuned, because COIL will continue to push out resources such as one-pagers, webinars, and they're both for residents and healthcare providers. So I just want to get to this question about the medical aid in dying. Someone said, where do I get information on it, because my hospital has opted out? So this is for anyone who would like to address that.
So, I mean, from my standpoint, a lot of times the Wendys laws kind of go into effect. It takes some time for it to kind of come into process. So I can tell you in Oregon, the medical aid in dying came into effect in 1997, but it took about 5 years for that to actually kind of come into fruition, because part of that is really education for the providers in themselves, because this is something new in the state of New Jersey. So before the first prescription was given in Oregon after it came into law in 1997, it was several years after. So from my standpoint, I mean, the most information we can really get overall is from NewJersey.gov, where it kind of goes over medical aid in dying, kind of goes over several questions regarding it. From a physician standpoint, it is still a process where education needs to be provided to providers here in the area, so we can know who to refer to in order to make sure that our patients can get the most information. So it is still something that's in progress. I'm sure the pandemic kind of affected that as well, but there still needs to be much more education for the community as well as the providers.
And I think the second part of the question, I think, was about my hospital. Is that right? I think I saw something.
They said that their hospital has opted out. So.
And that's part of the problem. Physicians or healthcare systems can opt out. So if you wish to, it's because it's a personal right, but it's also a personal right of the medical provider to opt out, and it's pursuant to the law. They would have an obligation, they being the hospital, to transfer you to another hospital system that that did not opt out.
Got that. Okay, and the next question that we had was, does New Jersey have an advanced directive for dementia patients specifically?
Claudia, you want to address that?
Oh, you're on mute.
You're on mute.
1 second, let me unmute you.
Sorry about that, forgot. Yeah, there wouldn't be a specific advanced care directive for a particular disease. It would just be a matter of, it's the same one that you'd use for any of them. And it would be a matter of timing, like how far into dementia they are. I mean, it doesn't necessarily, the disease itself doesn't necessarily make you incompetent to sign. You would just want to make sure you're getting the person, on a good day when they're lucid, when they're actually competent to sign. So it's more of a timing thing, not so much what's in the document itself.
Got that. Thank you. So for either Claudia or Gerald, many people cannot afford an elder law attorney. What is the best website they can obtain the durable financial / healthcare documents?
First of all, some legal websites, you can get some good documents. They're okay. I mean, are they great? No, they're not great, but they're certainly they're certainly valid. There's a lot, but I mean, as Claudia already indicated, there's a lot of value about going to an attorney. I mean, you're going to get a form document. It is valid. Will it meet your needs? It may, but it also may not. It needs to be state specific under your jurisdiction. I see all the time people coming to us with legal documents from the law firm of Staples and Office Depot, but I think Office Depot has since closed, but I think you get my point. Those documents are valid, but they need some meat on those bones, if you understand what I'm trying to say. And they need a sandwich. So but I mean, I'm not here to promote any individual websites. But I will say, if you cannot afford an attorney of any sort, I would strongly suggest you're contacting if you live in New Jersey, contact your county surrogate's office. They offer free wills and free financial and healthcare powers of attorney and advanced directives and the like. So I would first reach out to my county surrogate's office, where it's a volunteer attorney. For example, I know in South Jersey, I can't tell you what happens in North Jersey because we don't practice above Mercer County. But, you know, if you're in, for example, in Camden, Burlington County, contact the county surrogate's office, and they can help you. Maybe not now because of the COVID pandemic, but in normal times, you should be able to get some quality documents by a volunteer attorney.
Thank you. And I think we have time for one more. So many people have tried to encourage their loved ones to complete an advance directive, but often find their loved one doesn't want to have a conversation about it at all. Is there a different type of approach, or do you have like a conversation starter that patients and family members have responded to in a positive way? Anybody?
So I can talk about this just a little bit as well. So I mean, I think yeah, I think it's a really difficult conversation. We talked about that before because it's really hard to think about, you know, death and dying, and it's just not a typical conversation that we have, you know, over our kitchen table. But I mean, some things that you can do to kind of start that conversation, and this is something that, you know, people may have experienced themselves, is that personally, even for myself, if I had a family member who, you know, who died a couple of years ago, and was in the hospital setting, was in the ICU setting, and then eventually, you know, coded and died in the hospital. I mean, at that point, you know, if you have something where you had a family member who's had a serious medical illness, I mean, that might be an eye opener. That might be a time to really bring up this conversation. It might be a good place to kind of start on as well. Other people, what they do is they typically, if they've seen something, even a movie or something they read, an article, those are kind of ways to kind of bring up this topic as well, to see if you can lay a sneak in a little bit of a foundation for what you want to talk about. And like I mentioned before, it's not something where this conversation has to happen all in 1 second, but sometimes you need to plant a couple seeds just so you can watch it grow and revisit it in a couple days and a couple weeks, just to make sure that that you can have a fruitful conversation. So some people, it's not easy, but it's important to start. I mean, getting that conversation started, I think, is definitely an important first step.
Got that. Thank you. And looks, we have time for one more quick one. So one of our attendees said they've had the pleasure of working with Dr. George over the past few years, as well as referring to the Rothkopf Law Group. And they wanted to reiterate that it's important for people to understand that advanced directives can have timeframes written in. So an advanced directive does not mean all or nothing. I don't know if anyone wants to elaborate on that any further, but it's pretty.
I can talk to you specifically about definitely the POLST form. So the POLST form is a practitioner's order for life-sustaining treatment. It's a medical order. So there's a few different sections in that, but the first section is really goals of care. And that's a section where you can be as specific as you want it to be, or as broad as you want it to be. So in that specific time, or in that specific section, I'm sorry, you can mention that you want to be a full code, or you want to have all these things happen until a certain time frame. Some people choose different things, like their grandchild's wedding, or their anniversary, or a birthday, or it doesn't matter, but there might be a certain time frame where they want to be a full code, they want to have everything done, and they want it revisited. And just to kind of talk about what we said before, is that these conversations and these medical orders can always be revisited. They can always be updated as well. The different life circumstances can happen, and you can always, you can change at some point if you had some type of life event, which is specifically set on that. And that's for us to respect, because our main goal is to respect your wishes, empower patients, make sure they're educated on their prognosis and their medical conditions.
Got that. Thank you. So I do want to say a big thank you to all of our speakers for taking the time to talk with us today. There's plenty of helpful and amazing information that you guys provided us. So I just wanted to say thank you again. And if there's anything else, any last words you guys want to say before we hop off for the rest of the day, the floor is yours. If not, but you guys enjoy the rest of your day.
Thank you very much, everyone, for participating.
All right. Thank you all.
Thank you, guys.
Take care and have a wonderful afternoon.